In this video, we're going to talk about privacy. It's a big deal in HR, so let's get going right now. Hi there, I'm Andrea Adams. This is HR Shop Talk. On the show, you get expert insight into HR. I encourage you to subscribe to the show or to the podcast to keep learning from my smart and experienced guests. Today, my guest is Gayle Wadden. Gayle is a lawyer and recently launched a platform to help Canadians understand their compliance issues. A big part of that is privacy, and so that's what we're talking about today. Hi, Gayle.
Hi, nice to be here.
Yeah, thanks for coming. So, privacy. I feel like this is a topic I never really got, but anyway, let's get started. Can you provide an overview of privacy as it relates to HR?
Sure. And I start by saying I can understand why, maybe feel like you never really got it. This is a really complicated area, particularly when it comes to employment. So to start off with, HR professionals deal with personal information every day. So, information such as even just full names, dates of birth, address, social insurance number. They have financial information. They may have family information, may have medical information. Like when you think about the kind of information that an HR professional actually has access to, it triggers a lot of privacy concerns and obligations. In terms of an overview, what I'll say is what makes it tough is that privacy is governed in a multitude of ways in Canada. So the information might be covered by privacy legislation, or it might also just be covered by the general law regarding privacy, which comes from judge-made law, or what we call the common law. But at a high level, every HR department has to ensure that it collects, uses, and discloses any personal information in accordance with the relevant privacy law.
So what goes into collecting?
Collecting can be really broad, right? It's when you first hire someone, there's a lot of personal information that you collect. You're getting their, you may have them fill out sort of the tax form. You're getting certain financial information. You're getting their social insurance number. Collecting can even amount to, even before somebody's in an employment relationship. Think about if you're doing interviewing and you have people actually signing in for an interview. That is collecting personal information or information on a resume or, maybe as part of a cover letter. Anytime where you're actually, taking personal information from an employee, that's collecting.
And then moving on to using, what does that mean and what are the limitations?
This is where it all gets, pretty complicated because there are different obligations that apply depending very much on very different circumstances. So using and disclosing often kind of go together.
Okay.
You think about it, that information you have, you're maybe using it and also disclosing it to a third-party payroll provider, right? You're now sharing that information with somebody else, or to a benefits provider. So they often are kind of intertwined. Mm-hmm. The issue and why I can't give you sort of a straightforward answer about limitations is that the legislative sort of landscape for this stuff is not crystal clear. Federally, we've got something called PIPEDA, the Personal Information Protection and Electronic Documents Act.
Yes.
That applies only to a certain category of employees. So it applies to employees who are, the business that's engaged in a federal work or undertaking. Yeah. Kind of a smaller class of employees. Some provinces then have their own legislation that applies. So BC, Alberta, and Quebec, they do. And their legislation does apply more broadly to the employment relationship. There is also other legislation in each province that if you're a public institution, there's different legislation that applies. If you're a healthcare type institution, there's different legislation that applies. So there isn't one, I can't point you to one piece of legislation that sort of applies and covers this. The reality in Canada is that a lot of the privacy obligations around employment, in the employment context, come from the common law. So just the general right to privacy and sort of what that extends to.
Okay. Is there an American equivalent?
Not really. So privacy in the US is also done more generally on a state-by-state basis. Okay. And again, I don't have a huge sort of working knowledge of the US privacy legislation, but there are, for example, generally, so not just in the employment context, but sort of just general privacy, some states have much stricter legislation than others. So California is kind of known as a state that's got, more robust privacy legislation. More broadly than the US, there is what's called the GDPR, which comes out of the European Union. That is influencing kind of the direction of privacy laws in a lot of countries, including Canada, and parts of the US as well.
Have we talked about this? What qualifies as employee information?
I think we sort of briefly mentioned it. Like what I would say is, again, that this concept of personal employee information is only relevant in some cases. So just in the provinces that have that specific legislation.
You're talking about those provinces with the legislation. What about the provinces without the legislation?
So if you are in any province other than BC, Alberta, or Quebec, and you are not involved in a federal undertaking, work, or business,
right,
there is no generally applicable privacy law to employment information.
Really?
Yeah.
Huh.
There may be, but this is where I just want to I hate this. It sounds so much like a lawyerly answer, but it is just sort of the reality because it's a bit complicated. There could still be other information or other legislation that applies. So if you are, a public institution, there is legislation in those provinces that may apply to like governments or municipalities or healthcare. But if you're just a general private sector business, there is no legislation that applies.
Okay.
You're fully governed then by the common law.
Okay.
And that law, there is still an obligation to essentially protect privacy and, be respectful of the privacy of your employees and all the information you have. Right. And there's law that's developed around what expectations of privacy an employee has.
So what are some principles of good practice with respect to privacy in HR?
Yeah, this is a really good question. And here we can kind of get some concrete answers because there are some good practices that apply whether you've got legislation that applies to you or not. So first, only collect personal information that is really necessary and limit access to personal information to only those people who really need it. Mm-hmm. So it's a lot easier to protect personal information if you limit what you collect in the first place and if you limit the number of people who have access to it. So, and that's an exercise of turn your mind to like, what do we really need? And that will vary, right? Some jobs, you may require somebody's driver's license, or you might require, a medical test of some kind because you need to know that they're physically fit. But you got to think about, what do I really need for this job? The second really important one, and I think most people know this, but we really can't emphasize it enough, is to make sure that you have clear policies and expectations. Policies, when it comes to privacy, are really important. But it's not enough to have the policies. You've got to regularly remind your employees about the policies, and you have to actually abide by the policies. Courts in particular will look at, what were the policies? What were employees told about how their privacy was going to be, kind of guarded and protected, and what privacy they had? But they will also look at, but what did you actually do? Did you actually operate in accordance with those policies, or were things totally different? Right. So it's not enough to just have the policies. You've got to follow through. It just happens, right? Time goes by, or even new employees are hired and maybe you haven't told them about the policies, or you change the policies without telling employees. There's a lot that can easily happen just inadvertently, right? In the day-to-day. Another really good practice is employers should give employees access to their own personal information so that they can verify it and correct errors.
Right.
That can be done, on a periodic basis, making sure that, you're operating on information that is correct and that employees have a chance to say, well, look, that's not right anymore, or that was never right. I'm not sure where you got that information from. At a really practical level, there's just a couple of others. If you can, avoid sending sensitive information electronically, right? There's a lot of cases that kind of come up with inadvertent disclosure of information because you sent it to the wrong people, or and just be really careful if you are sending sensitive information electronically. Check and double check to make sure you're really careful about where it's going. Another one is, when there's any sort of disputes that come up about an employee's pay or rights, those should be dealt with by HR, not the employee's supervisor. So what information is necessary to be shared and discussed to deal with that issue? And it kind of goes back to the very first point about limiting the number of people with access to that information.
Mm-hmm.
Suddenly, if you're bringing in supervisors or other people, they're getting access to a lot of information that would be better addressed if it was kind of just all kept within HR. And I can give you one other, this kind of goes a bit to the sending of information electronically, but this is, I just think, a good little practical anecdote. So, even when you're sending things like meeting requests, think through what sensitive information you might be including in that subject line. So an example is, this is an actual case where a meeting request was sent to an employee for a disciplinary interview. So they were going to be talking about the disciplinary action being taken against this employee. And the subject line actually indicated, the reason for the interview, right? That this was disciplinary action. It turns out 17 other people had access to that employee's calendar. So 17 other people now knew that she was being disciplined because the subject line that shows up in her calendar said discipline interview, right? Or whatever the exact language was.
Right.
So privacy, breaches or kind of not being mindful of people's privacy, like it can really creep up on you.
If you found this helpful, subscribe or hit like. And the question for today is, have you ever been involved in a privacy breach? What was that like? What was the breach? Let us know in the comment section below. You just talked about that. You hear stories of people accidentally sending out a spreadsheet with employee information or private information to the wrong email list. What should an employer do when something like that happens?
Yeah, so the very first thing you should do is contact a lawyer, unquestionably. There can be some really serious implications to a breach. And as we've already talked about, because the privacy laws in Canada are so complex, you're likely going to need legal advice to determine exactly what you need to do. So depending on which legislation applies to you, you may need to notify every individual about the breach. So depending on, again, like I said, which law applies, there's notification requirements actually to the individual.
Okay.
You may have to notify the privacy commissioner of the province or federally. You may also have to notify third parties. So you may have to notify anybody else that you'd otherwise provided that information to. And the tests kind of for where you have to, whether you have to do each of those things, varies a bit on the jurisdiction and depending on the sensitivity of the information. So a lot of the legislation kind of has different requirements depending on what exactly was it that was breached. And the reason I recommend, contacting either your in-house legal or external counsel right away is you can also be exposed to some pretty significant penalties or lawsuits, right? So there are individuals can bring litigation against you for breaches of their privacy. And the way that you want to handle all of that and even manage things like the PR around, a breach, right. There's a lot of implications to it. So it's really not something I recommend, fully dealing with on your own. Get some advice at least and help you kind of decide which direction you need to go from there. Maybe one thing I will mention too, there is some of the penalties, and particularly if we see amendments to PIPEDA again, as had been introduced before the election, they sort of died, but we expect that'll come in again. The potential penalties for breaches are drastically increased if that comes through again. So it's not something to take lightly.
Right. Okay. So employees often have expectations around their own privacy, expectations around their email, their work email, or their Facebook account. Is this relevant to privacy legislation? And in any case, what are employees entitled to or not entitled to?
Yeah, it's a really good question. And you're right. It's a really interesting sort of area of the law. So this isn't governed by legislation generally. It's often a question of company policy and contract. So starting point is the law says that employees have a reasonable expectation of privacy in the workplace.
Okay.
And this extends to information that's on their computer, particularly if personal use is permitted. So, a lot of workplaces say, we provide you with a smartphone and you can use it for your own, personal use too, right? Or we provide you with a laptop and, you can use it to, go on and look at personal things as well. So the law says that employees do have a reasonable expectation of privacy in any of that.
Yeah.
And so there are generally limits on what an employment can do. But that expectation of privacy is totally affected and determined by the employer's policies and anything that's in your employment contract.
Okay.
So an employer can have policies that say, look, everything, yes, you can use it for personal use, but we have a right to all of the information that is on that laptop that we provide you with. We have a right to, access all of that. We have a right to take that laptop back whenever we want. There can be policies around that. There can be policies around acceptable use. We allow you, you can't use it for anything illegal or improper. And we have a right to check and make sure you're not. And if that's the case, the court will say, that is the parameters of your privacy. You can, so an employer can absolutely really whittle away at that privacy by saying, these are our policies. But that's where, kind of as I mentioned previously, like courts will look at how the policy actually operates in practice, right? Do you actually follow that policy? Is there what is the totality of the circumstances is kind of what they look at to see what you're entitled to. Things like Facebook and that you mentioned, things that an employee is putting on public posts. The law generally says there isn't an expectation of privacy in that. When you're putting something out, and there's a bit of a distinction between, are you in private groups or public groups? But even still, when you're putting information out there to a whole bunch of strangers, potentially, that can be copied and disseminated in any possible way, your expectation of privacy in that is, at most very low.
So a final question here. What is something people might not know about privacy at work?
I think there's a lot of confusion around privacy at work because it isn't regulated. Yeah. Unlike some of these other areas, it's just not regulated in a straightforward way. There are so many different variables that might apply. But generally, I would say, kind of on the employee side, I think a lot of employees would be surprised to know how much their privacy rights can be limited by the employer, through things like policies and their employment agreement. There is that general sort of right to privacy, but, use around things like emails and all of that can be curtailed. And I think a lot of employees don't realize that and need to understand they need to pay attention to those policies and whatever terms are in their employment contract. I think, on the flip side, I do think there's a lot of employers that don't realize that it's not enough to just have policies, on paper somewhere about these issues. The way that privacy is actively managed in the workplace will impact on how much you can rely on those policies, particularly if you're talking about anything before a court. So, again, not enough to just create a privacy policy or a technology policy or, one of these things that deals with the use. You actually have to, make sure employees know about it, make sure they know about changes, remind them of it from time to time, actually enforce it, it has to be the way that the business and the company actually operates, as opposed to just, we've, 5 years ago, we wrote a policy and it sits here and that's the end.
Thanks, Gayle. That was validating. Now I understand why I'm confused about privacy. Gayle and I also did an episode on compliance, and the link to that's right beside me. Thanks for watching, and see you next time.